sure, sorry.
And before we go any further,
Yeah.
this is our town attorney, this is Chris Ledger, and he's our attorney for the town. And the council members here, I think you're all familiar with, Mr. Dumo, Gary Levac, Leo Levac, Mike Brissett, and I'm Robert Leonard.
And when did we make a motion to hire Chris?
Last meeting, you authorized me to hire the town attorney.
We authorized you, sir, to look into hiring a town manager with our consent, but when did we hire Chris?
Well, I hired him after I got my letter from, I hired him after we got the letter from Mr. Peabody yesterday. It was, I got the letter, I think it was today, or yesterday. I got the letter yesterday afternoon at 3 o'clock, 3:30.
So you're paying him, right?
What do you mean I'm paying him?
You hired him.
Oh, the town. You authorized me to hire an attorney.
We authorized him to hire an attorney.
Yeah. That was the motion made, authorized me to hire an attorney.
I just not seen that motion.
That motion was made.
The motion was made.
You have it on the minutes?
We asked you to look,
Minutes haven't been completed yet.
we asked you.
The motion was that you authorized me to hire an attorney, because that was a specific part of the meeting. And it was three, I think, 3 in favor, and 2 opposed, again, I don't know. But I was authorized to hire an attorney, and that's the town attorney.
October 16, hire a town attorney for Bob Leonard.
There was a stipulation. Did you contact Ezzy's?
We did,
Okay.
and they have, and was it Yvette called, Yvette told me that the people that would handle that, because she's on vacation, would be, I told you his name earlier today.
Peter Clavette.
Peter Clavette, yeah, and Madawaska. Now, they don't even know if there's a clause in there for town attorneys. I don't know, you people, I wasn't aware that Izzy's had an attorney clause in their contract with that town of Van Buren. Are you aware of that? Neither was they.
The reason we brought it up was because they've got the insurance policy for our public officials.
But they have, the MMA is the one that's been supplying us with our legal advice up to now,
That's
but we haven't
possible,
used, well, we haven't used them, we haven't used any other person. But all I got, I wasn't gonna hire an attorney until I got the letter from this gentleman here, Mr. Thad Zamonsky, and I got the letter yesterday afternoon, and I figured, well, if he's gonna have an attorney, we have to have an attorney. You people authorized me to hire an attorney, and there he is, he's a town attorney. Any other questions?
I have some procedural motions that need to be made prior
Yes, sir.
to the hearing.
You can come right up here at this table. if you
Okay.
like.
Why don't we have spoke with them?
Come on, sure.
Sure.
Randy, if you
Okay.
want to come up.
These are preliminary to the hearing. I object to the hearing taking place for a number of reasons. First, this town has adopted, the voters of this town, at a town meeting, have adopted the town manager's plan. That's a statute, and it's a statutory process. And that statutory process is very clear about the removal of a town manager. Your charter states as follows. Town manager plan. Except as provided in this charter, this article will be in compliance with Title 38 MRS Section 2631 to 2639. That's what your voters voted in. And that defines the scope of your authority to act against my client in an effort to remove him. Now, this counselor, Mr. Brissett, said, well, we didn't terminate him, we removed him. Okay. Here's your charter, removal. It's in very large script. It says, the town manager may be removed or suspended for cause by the council in accordance with the provisions of Title 38 MRS Section 2633(3). You put the cart before the horse. You voted to remove him. That's the only town vote on record. The statute requires a public vote to initiate the statutory procedure. And that procedure begins with a preliminary resolution. You tried to give a resolution after you removed it. And the resolution was not the product of a public vote. I looked at every single one of your minutes. There's no vote here, and I've marked them, and I'm gonna put them on the record. There's no vote
How
here.
come they're not signed?
There are signed ones in your copy. I just got ones
How
that are
come
unsigned.
yours are not signed, sir?
You want the signed ones? Go in your office and get them. They're the exact same ones. If you don't want to look at them, that's fine. I just have to put
I
my
just
motions.
asked you, I asked you a
There's
question why
no,
it wasn't signed.
these are
Thank
the
you.
ones that were provided. There is no public vote to initiate the statutory process for removal. It doesn't exist. You didn't vote, and you have to vote to initiate that process. There's a removal resolution that's signed by the chair. Where's the vote? You have to follow the statute expressly. It's very technical, and he has rights. And his rights are to be removed only pursuant to that process. You have to follow. That's number one. Number two, we take the position, my client takes the position, that this termination is the subject or the product of retaliation for his lawful exercise of rights pursuant to Maine's Whistleblower Protection Act. This removal has nothing whatever to do with the basis given in the vote to terminate him or remove him, however you want to call it. It's illegal either way. And the resolution, which states exactly what you moved when you moved to remove him on September 22nd, which is for insubordination for leaving a meeting. Now, I listened to tapes. I listened to the tape of the September 14th meeting. And that meeting opened with the chairman, and that chairman said, an opening, the assessors meeting. Just because the same personnel sit on two boards doesn't mean you don't need two meetings and don't have two meetings. And every time people do have meetings on the same night, you open the assessors, you close it, and then you open the council meeting. And when you were sitting in the assessors meeting, you are wearing the hats of an assessor, a board of assessors. When you sit in a council meeting, you are wearing the hats of a counselor. It is incompatible for my client to be at the assessors meeting. He doesn't have to be. You cannot show me one provision that requires him to be there. In fact, it is incompatible. Why? Because under state law, he's the treasurer, he's the tax collector, and he's the town manager. None of those people have anything to do with assessing. It's incompatible. The roles are incompatible. Now, you made a big deal of an opinion by the Maine Municipal Association. Now, I've marked as Exhibit 7. I'm going to put this on the record. Here's the question that Mr. Brissett asked. I would appreciate your guidance. On Monday, we had a very short council meeting. You had no council meeting on Monday. I listened to the entire tape. The council meeting was never commenced. Ever. You had an assessor's meeting. And so the answer came back, you know, if you adjourn a council meeting and then you suspend it to a date certain, as long as that date certain isn't too far in the future, then you're going to be okay, arguably. There's never been a case to decide it, but arguably under the Freedom of Access Act and the public notice requirements. But that's not what happened here. The tape doesn't lie. You can't dispute it. I watched it. You can watch it right now. It's going to say the same thing. It's not going to change. You commenced the assessors meeting. So you noticed the assessors meeting.